Hello, colleagues. Welcome to our webinar. We don't start immediately. We give like 1 more minute to be joined by more attendees. Can we start, Andrew? Okay. Hello, colleagues. Welcome to our webinar, the AI Legal Frontier, U.S. Frameworks and International Perspective, brought to you jointly by the IFLA Bibliography section and the IFLA Artificial Intelligence Special Interest Group. My name is Rehab. I work at the Bibliotheca Alexandrina in Egypt. I am the chair of the IFLA Bibliography section, and I'm delighted to co-host this webinar today with Andrew. He's Andrew Cox, the convener.
Yes. Sorry. Yes. Welcome, everybody. I'm Andrew Cox from the IFLA Special Interest Group on AI, the convener of that. I think it's going to be a great session. We've got a great speaker, and Rehab's done a lot of organization of this session, so I think you'll enjoy it.
Thank you so much, Andrew. And like Andrew pointed out, it's a much awaited session, and it's a hot topic. We don't need lengthy introduction of this topic, since it's a hot topic that is a concern for all of us, on how the rapid evolution of AI is reshaping the legal policy and operational landscape for libraries worldwide. Everybody has come today with looking for responses, for answers, for updates, or just more information on how AI is affecting work collections, copyright, and cultural responsibility. So what do you have in the program today, Andrew, to address this topic?
Yeah, so we've got a fantastic guest speaker who's going to present the view from the United States and some international coverage. And then we've got a panel, chance for you to ask your questions of the speaker, but also of our panel. And we've also got a little bit of a questionnaire lined up for you so you can share your opinions, and hopefully that will yield something interesting too.
So before we go introducing our keynote and our co-panelists, because we are in the panel, all of us, we are going to make some housekeeping. So permit me to share my slides. Okay. So the webinar will be recorded, and we make the recording available soon on our web pages and channels soon after the webinar, except for host, panelists, and speaker. Mics and the video are turned off. So if you have any question, we advise you to use the Q&A box to add your question for easy identification and by us, because in the chat, the question risks to be buried in the lots of greetings and sharing of links. And if you are free to turn the closed captioning in your own language, or if you find that sometimes the terminology is not topic related, English is fine and will enable you to follow with the speaker and with the panel. We take the opportunity to introduce you to our upcoming, to advertise our upcoming event. There are webinars or our activities in the IFLA upcoming Congress in Busan. So we have two upcoming webinars for the IFLA Bibliography section, part of our topics in National Bibliography, the virtual event series. One on 30 June. The title, Libraries and Publisher Workflows, Tools and Progressive Partnerships between libraries and publishers. And the other session is on the newcomers' generative AI content in our collection, and how the vendor, library and vendor partnership address this. These two are planned for 30 June and 8 July respectively, and we have opened the registration just yesterday. In Busan, the bibliography section is having two open sessions, joint open session with other IFLA committees. One on metadata for open knowledge, scheduled for Tuesday, August 11. And one on cultural memory in motion capturing and documenting film, music, and emerging media. And this one is scheduled on Wednesday, August 12th. And the AI stick for you, Andrew, to present.
Yeah, we have got, we're involved in a few of the open sessions, but I particularly wanted to mention a couple of satellite meetings. So if you're coming to Seoul and Korea and Busan, it'd be great if you came along to those two satellite meetings. One's about librarians supporting research integrity. That's just before the main conference. And then there's one on implementations of AI in public libraries. That's after the conference. So if you are coming to Korea, please join us for those. You can sign up for those now. And we do have some sessions open sessions in the main conference as well, if you want to look for those. It'd be great to see you in Busan. I'm sure all our speakers and panelists would say hello in Busan.
Thank you. And now it gives me a great pleasure to introduce our keynote for today. Chris, please join us here in the lobby. So Chris Weston is Senior Counsel in the Office of Policy and International Affairs at the U.S. Copyright Office, which he joined in 2004. He has extensive experience in domestic and international copyright law and policy, including leading and contributing to major copyright office studies on artificial intelligence, libraries and archives, press, publisher rights, orphan works, and mass digitization. Internationally, he represents a copyright office at the World Intellectual Property Organization Standing Committee on Copyright and Related Rights, and manages portfolio for the European Union and the Caribbean. He graduated with distinction from Georgetown University Law Center, and prior to his legal career. He spent 6 years in the music industry. We are happy also to briefly introduce Cory Lampert, who is professor and head of digital collection at the University Library of Nevada, Las Vegas, Special Collection and Archives. And in IFLA, she has been very active, including that she was the convener of the Big Data Special Interest Group and the former chair of the Information Technology section, and Haliza Jailani, who is Senior Deputy Director, Senior Principal Librarian for Resource Discovery and Management at the National Library Board of Singapore, and she is my colleague in the IFLA Bibliography Section Standing Committee. Over to you, Chris.
Thank you very much for that kind introduction. I would like to have the first slide, please. Thank you. So thanks again for having me back to speak to IFLA again. Today's topic, the AI Legal Frontier, U.S. Frameworks and International Perspectives, is a very rich one. And what I hope to provide is a kind of roadmap to the most important landmarks in the copyright and AI landscape. Next slide, please. I'm going to divide my remarks into 3 sections. First, I'm going to discuss AI and copyright policy in the United States. Second, I'm going to hit some of the highlights of the vast constellation of AI and copyright litigation in the United States. Finally, I will discuss some copyright and AI policy issues in the European Union and the United Kingdom. Next slide, please. But before we jump in, I just wanted to do a brief review of what I talked about when I spoke to IFLA in August of last year about what the U.S. Copyright Office has been doing. We completed 3 parts of a comprehensive copyright and AI report. Part 1 discussed digital replicas and recommended federal legislation to protect individuals against unauthorized digital replicas, also known as deepfakes, of their likeness or voice. Can I have the next slide, please? Great, thank you. In part 2, we wrote about copyrightability, and following up on our 2023 policy statement, again confirmed that to be copyrightable, a work using generative AI must have its expressive elements created by a human. Prompts alone are insufficient for human authorship. And the last part to date, part 3, generative AI training and licensing. We concluded that many uses of copyrighted works to train generative AI are transformative and a fair use, especially when the AI system is used for analysis or research. However, and I quote, making commercial use of vast troves of copyrighted works to produce expressive content that competes with them in existing markets, unquote, is unlikely to be a fair use. Also, the best outcome is a robust licensing system, including extended collective licensing if necessary. So for our first section, I have selected a few bills that have been introduced in the United States Congress concerning copyright and AI. And I'll also discuss the copyright section of the executive branch's AI National Policy Framework. Next slide, please. The first bill I will discuss is one that right now seems to have the best chance of becoming law, so I will go into a little more detail on it. It is the No Fakes Act, and No Fakes stands for Nurture Originals, Foster Art, and Keep Entertainment Safe. This was initially introduced last year. It was reintroduced in May of 2026. It would establish an individual's intellectual property right to authorize the use of their voice or visual likeness in a digital replica. It applies to all individuals, not just the commercially viable or famous. Upon the death of the individual, the digital replication right is transferable, licensable, and exclusive to the executives, heirs, licensees, or devisees of the individual, and the like for 10 years, renewable every 5 years for a maximum of 70 years. During the life of the person, for adults, the license duration is no longer than 10 years, but it can be renewed. The license must be in writing, and the license agreement must describe the intended uses of the digital replica. There are also additional license and guardrails for minors. The liability for distributing or making available an unauthorized digital replica and for distributing a product or service that is primarily designed to produce unauthorized digital replicas of specific individuals has only limited commercially significant purpose or use beside that, or is marketed for such use. There are removal obligations for online services with a notice and takedown system. In a new section that was just added for this version of the bill that was introduced in May, there is an exclusion for nonprofit libraries or archives that provide public or researcher access to their collections and have a public service mission. They're excluded from liability. Excuse me. Also excluded from liability are accredited nonprofit educational institutions, so long as the activity is not undertaken for the purpose of commercial advantage. There are also specific First Amendment exclusions, such as for documentaries, criticism, comment, scholarship, satire, parody, or news. This bill has been endorsed by a wide variety of stakeholders, including the recording industry, the motion picture industry, YouTube, OpenAI, SAG-AFTRA, TikTok, and Spotify. Can I have the next slide, please? So next up is the TRAIN Act, and that stands for Transparency and Responsibility for Artificial Intelligence Networks. It was initially introduced in 2024, then reintroduced in January of this year. This bill would authorize copyright owners with a subjective good faith belief that their work has been used to train an AI model to request the clerk of any United States district court to issue a subpoena to the generative AI model developer. And that subpoena would be seeking disclosure or records sufficient to confirm whether the work or works were used to train the model. Then, if a developer fails to comply with a subpoena issued under the Act, that failure establishes a rebuttable presumption that the developer made copies of the copyrighted work. Next slide, please. After that, we have the CLEAR Act, or Copyright Labeling and Ethical AI Reporting. This was introduced in February of this year. It would require that a notice be submitted to the Register of Copyrights with respect to copyrighted works used in building generative artificial intelligence models. The notices must contain, first, a sufficiently detailed summary of each copyrighted work in the training dataset, and second, the URL for that training dataset if it is publicly available on the internet at the time the notice is submitted. The bill's requirement of a sufficiently detailed summary for each work in the dataset is different than the European Union's AI Act requirement of a sufficiently detailed summary of the content used for training, which we will discuss soon. The EU's requirement applies to a potentially narrower set of general-purpose AI models, usually taken to mean foundation models, whereas the CLEAR Act applies to any generative AI models. More importantly, the EU's requirement calls for an overview of the data sources and sets involved, including private and public databases, whereas CLEAR requires disclosure on a per-work basis. Next slide, please. Next is the COPIED Act, which stands for Content Origin Protection and Integrity from Edited and Deepfaked Media. This was introduced in April of 2025. First, it directs the National Institute of Standards and Technology in consultation with the U.S. Patent and Trademark Office and the U.S. Copyright Office to facilitate development of guidelines for voluntary consensus-based standards and for detection of synthetic content, watermarking, and content provenance information. It seeks to mandate that tools for creating AI-generated or AI-modified content shall allow users to embed metadata, what it calls content provenance information, that indicates that the content is AI generated or AI modified. The same for allowing users to embed content provenance information into any digital representation of a copyrighted work. These markers should be secure and not easily alterable. The bill would prevent the knowing removal or alteration of the content provenance information and includes provisions to prevent misuse of content by restricting the use of provenance-marked digital copyrighted non-AI content for training or generating AI models without consent from the content owner. Next slide, please. Finally, in the congressional arena, we have the Creator Act, which stands for Creative Rights Ensuring Artists' Technique and Originality Are Reserved. This was introduced just last week. It would establish a new federal intellectual property right that protects visual artists from the unauthorized commercial use and public distribution of AI-generated works that constitute a stylistic impersonation of their art. This right would be distinct from copyright or trademark. Also, it does not extend to ideas, concepts, genres, artistic movements, commonly used visual styles, or artistic methods that are not publicly associated with the work of a visual artist. Can I have the next slide, please? Moving on to the White House, we have the Executive Branch AI National Policy Framework. This was introduced in March of 2026. Section 3 of this document is entitled Respecting Intellectual Property and Supporting Creators. It first states that while the administration doesn't think that AI training infringes on copyright, that question should be a matter for the courts. Also, Congress shouldn't interfere with courts' fair use decisions. On that last point, it's interesting to note that a Trump ally in Congress, Senator Blackburn, has proposed an amendment to the Copyright Act to the effect that generative AI training should be presumptively not a fair use. Next, the framework recommends that Congress consider enabling, but not requiring, licensing frameworks for rights holders to collectively negotiate with AI developers without incurring antitrust liability. To date, no such legislation has been introduced. Third, the framework says that Congress should consider a federal digital replicas framework, protecting individuals from the unauthorized distribution or commercial use of AI-generated digital replicas of their voice, likeness, or other identifiable attributes, with First Amendment exceptions. This is, as we've seen, consistent with the No Fakes Act, as well as with the Copyright Office's digital replicas recommendation. Finally, the framework recommends that Congress continue to monitor evolution of copyright and AI case law and evaluate whether additional legislation is needed to fill gaps or protect authors. Next slide, please. So that does it for U.S. policy. Now let's move over to U.S. litigation. Next slide, please. As we can see from this slide, as of June 1st, 2026, there have been 114 cases filed in the United States against AI developers. Out of these, there have been two notable decisions on AI training, Bartz v. Anthropic and Kadri v. Meta. Both were brought by groups of authors alleging that the use of their works by the defendant AI developers infringed their copyright rights. Both were heard in the United States District Court for the Northern District of California, but by different judges. Next slide, please. First, Bartz v. Anthropic. In June 2025, the judge in this case, Judge Alsup, ruled on summary judgment that using books without permission to train an AI system was fair use if they were acquired legally. But he denied Anthropic's request for summary judgment related to piracy, finding that the piracy was not fair use. In September 2025, a settlement regarding the pirated books was approved by the judge for $1.5 billion, or roughly $3,000 per book, and the corpus of books is restricted to works registered with the Copyright Office, which equals about 500,000 titles. Next slide, please. Second, Kadri v. Meta. Also in June 2025, Judge Chabria ruled on summary judgment that Meta's use of books from shadow libraries was a transformative fair use. He did not find that the fact that the books came from pirate sites was dispositive. However, Judge Chabria explained in dicta that had the plaintiffs presented compelling arguments or evidence about market dilution, which is the idea that a generative AI system can generate works that are similar enough in subject matter or genre that they will compete with the originals and thereby indirectly substitute for them, that they may have won, and that future plaintiffs who develop a record of market dilution may succeed. Judge Chabria said, and I quote, "This ruling does not stand for the proposition that Meta's use of copyrighted materials to train its language models is lawful. It stands only for the proposition that these plaintiffs made the wrong arguments and failed to develop a record in support of the right one." An additional note on this case, claims related to alleged reproduction of pirated works during seeding in the torrenting progress by Meta remain active in the Northern District of California. Next slide, please. There has also been one notable decision on the question of AI authorship and copyrightability, Thaler v. Perlmutter. This was a suit against the Register of Copyrights by an inventor claiming that his creativity machine independently created a work of visual art and that the Copyright Office was wrong to refuse registration on this basis. You can see a reduced version of the work here. It's titled A Recent Entrance to Paradise. U.S. District and Appellate Courts ruled for Perlmutter, holding that the Copyright Act requires all eligible works to be created by a human and that registration was correctly denied. The Supreme Court declined to hear the case, so it is concluded. The decision does not apply to instances where a work was a mixture of human and generative AI authorship. That is being considered in other cases. I should note that the Copyright Office has registered thousands of mixed AI and human works where the AI's contribution was appropriately disclaimed. That issue of disclaiming AI-created aspects of a work has arisen in one of two ongoing cases on copyrightability, which are both on the question of mixed human and generative AI authorship, which I will discuss now. Next slide, please. The first of these cases is Allen v. Perlmutter, which is being heard in the Colorado District Court. It's a 2025 suit against the Register for refusing to register the visual work Théâtre d'Opéra Spécial created with generative AI. The finished version submitted for registration is on the slide. Here, the artist used 600 prompts to create the work. The Copyright Office said that the artist could have sought a limited registration covering only his post-generation edits while disclaiming the AI-generated portions. Allen refused this offer, and the case is ongoing. Next slide, please. The second copyrightability case is Surryast v. Perlmutter, being heard in the Central District of California. This is a suit against the Register filed in May 2026 for refusing to register a visual work combining artist's photo with Van Gogh's Starry Night painting. You can see how the works were combined using generative AI on the slide. In addition to challenging refusal of registration of the Surryast work, the suit also more fundamentally challenges the Copyright Office's human authorship requirement. Next slide, please. Now, moving on from U.S. litigation to EU and UK policy, I'm going to talk, of course, about the EU AI Act's copyright provisions, as well as some recent activity by the European Parliament and European Commission. Then I'll conclude this section and this talk overall with a look at UK copyright and AI policy activity. Next slide, please. Starting with the EU AI Act. It was adopted in January 2024. Rules for general purpose AI were in place by August 2025, and the majority of rules come into force and enforcement starts in August of 2026. The copyright relevant sections are in Chapter 5, Section 2, Article 53, Obligations for Providers of General Purpose AI Models. There are two important articles. Next slide, please. First, Article 53.1c, which says general purpose AI developers must, quote, put in place a policy to comply with union law on copyright and related rights, and in particular to identify and comply with, including through state-of-the-art technologies, a reservation of rights expressed pursuant to Article 4.3 of Directive EU 2019-790. Now, Article 4.3 is the opt-out text and data mining exception in the 2019 Copyright and the Digital Single Market Directive. There has been some dispute over whether this article is in fact fit for purpose to address generative AI. Additionally, under Recital 106 of the AI Act, EU copyright law applies to AI training activities regardless of where in the world they take place, provided the provider wants to put the AI model on the EU market. Next slide, please. The second provision relevant to copyright is Article 53.1d, which instructs general-purpose AI developers to, quote, draw up and make publicly available a sufficiently detailed summary about the content used for training of the general-purpose AI model, according to a template provided by the AI Office, unquote. AI Act Recital 107 provides some examples of what this means, listing the main data collections or sets that went into training the model, such as large private or public databases or data archives, and by providing a narrative explanation about other data sources used. Next slide, please. In addition to the AI Act itself, the European Commission's AI Office has produced a code of practice with a copyright chapter, as well as a copyright transparency template. The Code of Practice's copyright chapter was finalized August 1st, 2025. It is not legally binding, but signatories are presumed to conform with the AI Act provisions. The 5 measures in the copyright chapter are to draw up, keep up to date, and implement a copyright policy, reproduce and extract only lawfully accessible copyright-protected content when crawling the web, identify and comply with rights reservations when crawling the web, mitigate the risk of copyright infringing outputs, and designate a point of contact and enable the lodging of complaints. The Code of Practice was signed by most major generative AI providers, but was condemned by author and content groups as not providing sufficient transparency. Next slide, please. Speaking of transparency, at the same time it finalized the Code of Practice, the AI Office also issued the Copyright Transparency Template. This is a form that implements the AI Act's provision to draw up and make publicly available a sufficiently detailed summary about the content used for training of the general purpose AI model. It asks for 3 categories of information: general information, list of data sources, and relevant data processing aspects. It's worth noting that this template is not only about copyright, but privacy and research interests as well. Next slide, please. So far in 2026, the EU policymaking bodies have been quite active in the copyright and AI space. In March, the European Parliament issued a report on copyright and generative artificial intelligence, opportunities and challenges, which was followed by a Parliament resolution regarding AI and copyright, which stated that current legislation, such as the Copyright in the Digital Single Market Directive, is insufficient, and the EU needs supplementary legal framework. It resolved to protect news media, resolved that they need a working collective licensing market, including better opt-out tools, compensation for past uses of copyrighted works for generative AI training, a rebuttable presumption of use of works in generative AI training, and protection against deepfakes. Next slide, please. And slightly more recently, the European Commission in May opened twin copyright and AI-related consultations. First is the scheduled Copyright and the Digital Single Market Directive review, and this review is joined by a targeted copyright review. For that, the Commission is considering targeted changes to EU copyright law, stating that, quote, the existing EU regulatory framework, including the Copyright and the Digital Single Market Directive and the copyright-related provisions of the AI Act, and subsequent implementation measures, contribute to supporting rights holders in the exercise of their rights. However, they may not be sufficient to address the difficulties faced by rights holders in controlling and licensing their works for AI uses. Furthermore, performers face certain challenges in relation to AI-generated imitations of their personal characteristics and performances, impersonifications, which raise complex questions going beyond copyright protection. Unquote. This targeted review will also tackle other copyright issues that are not related to AI. Next slide, please. Moving across the English Channel to the UK, we see a more limited copyright and AI policy activity. The Intellectual Property Office launched a copyright and AI consultation in December of 2024. This consultation gave a list of options, including the government's preferred option of a text and data mining exception plus opt-out, along with an option for full licensing of copyrighted works for AI training. Comments were due in February of 2025. Around the same time, the Data Use and Access Act of 2025 was passed, and this required the Secretary of State for Science, Innovation, and Technology to publish an AI and copyright report by March 2026. Next slide, please. So in December of 2025, two departments, the Department for Science, Innovation, and Technology and the Department of Culture, Media, and Sport, produced a Copyright and Artificial Intelligence Statement of Progress under the Data Use and Access Act. So this kind of merged the IPO consultation and the Data Use and Access Act requirements. And this statement of progress revealed that of the approximately 11,500 responses to the Intellectual Property Office's copyright and AI consultation, 88% favored the full licensing option, and 3% favored the government's preferred option of text and data mining plus opt-out. Next slide, please. So in March 2026, the government issued its final report on copyright and artificial intelligence. It affirmed the results of the Statement of Progress, and I quote, in light of the strong views from the consultation, the gaps in evidence, and the rapidly evolving AI sector in international context, a broad copyright exception with opt-out is no longer the government's preferred way forward. We propose to gather further evidence on how copyright laws are impacting the development and deployment of AI across the economy. We will consider and engage stakeholders on other potential policy approaches. We will also continue to monitor developments in technology, litigation, international approaches, and the licensing market. This government report also involved other AI and copyright topics such as transparency, labeling, licensing, and digital replicas. Next slide, please. So that about covers it. I hope you found this information useful, and I'll be happy to take questions for a few minutes before we move on to the panel discussion. Thank you very much.
Thank you so much, Chris, for this extensive coverage of the AI landscape in US, UK, and EU landscape. And I don't know, didn't get, did we get a question from the audience? Cory?
Yes, we have a couple questions coming through the Q&A. I'll start with the question. I'll read it aloud. Would fair use apply to image and voice personal intellectual property principle?
That's an interesting question because the idea of intellectual property and an individual's image and voice doesn't really exist at the moment. Right now, protection of an individual's, at least in the United States, protection of your voice or your image is protected sort of on a state-by-state patchwork level. So each state has its own laws about, and it's usually under right of publicity or right of privacy. So, for example, if I take a photograph of you and I put that photograph on the web or I manipulate that photograph, you don't have any rights in that, any federal United States rights in that, because you didn't take the picture. You were just the subject of the picture. I, as the photographer, would have rights, intellectual property rights in that. You might, depending on the state, have right of publicity or right of privacy rights, depending, again, on the state and what happened to the photograph. So in terms of fair use is an intellectual property concept. So at this point, there's not really an intersection between fair use and individual images or likenesses or vocal similarities.
Thank you. I'll go to the next question. Libraries are receiving AI-generated content when building collections. Are any legal issues coming up for this? Is law emerging for authors of written work that is similar to the Creator Act for visual artists?
To answer the second part, I don't know. That's a very good question. Obviously, the issues that gave rise to the Creator Act for visual artists equally apply to authors of written work. In terms of the library issues, I believe that's a topic that we're going to discuss in the panel discussion. And since I'm not a library expert as such, I will leave that to the experts.
We have another question. This is an additional scenario that maybe we will get into more in the panel discussion, but I'll read it aloud so others can be thinking about it. A library in the United States is currently providing access to millions of pages of historical newspapers based on fair use. According to its policy, access is granted when the publisher is no longer active. The library does not conduct copyright clearance with authors and photographers, as there are hundreds of thousands of creators involved. The library is now working on a technological solution that will enable AI engines to access the full text of the newspaper corpus, including OCR. Opening the collection to AI engines will create significant exposure. What legal risks should the library consider? Chris, if you have any comments now, otherwise we can also tackle this in the next section.
Yes, that definitely sounds like something for the panel discussion. There are an enormous amount of legal considerations that would have to be thought about, most of which there aren't really solid answers for yet, because we are still, even though, AI has been on the front burner of copyright consideration since late 2022, it's still really early days. We only have 2 fair use decisions out of over 100 cases. So, it's hard to come up with responsible, definitive answers.
And we have a follow-up on the first question. Would fair use be applicable if federal copyright protection were to emerge on digital replicas, voice or likeness?
That would depend on, if just hypothetically, and I should have said this at the beginning, that anything I say is just my personal view and not the view of the United States Copyright Office. But hypothetically, if they were just included in the list of things that copyright protects, then presumably fair use would apply, barring any other statutory amendment that would say that it didn't apply. But it's a very hypothetical question, and it's impossible to answer for sure.
We can give a moment to see if any other questions come in. Thank you, Chris, for those comments.
Sure.
I'm not seeing anything at the moment. I'm sorry. Go ahead.
Can we pass to
I think there's
the,
somebody who's got their hand up who wants to ask a question. Should we allow them to do that? So someone's got their hand up in the Nikki Krauster would like to ask a question.
Please, Nikki, go ahead. Nikki, I'm not sure we're hearing you, just to make sure you're not muted.
Okay, until Nikki is able to turn off on her sound, there was some question coming in the chat asking about certificate of attendance. Yes, we do provide certificate of attendance based on if you have attended the big portion of the webinar. And for this, you can contact us. I think that Andrew has shared his email. I'm going to share my email as well in the chat. And please contact us for certificate of attendance.
Okay, it looks like we have a message from Nikki in the chat. It was a technical glitch, and we can proceed. Thanks, Nikki.
Oh, I'm not able to write at the moment. I'm sorry. I will share it later. But if you just email Andrew, we'll make sure to make you to deliver your certificate of attendance of this webinar. Shall we pass to the panel?
I'm sorry, before we move forward, I did see one more question come in, if we could just take a pause. This question reads, what is the acceptable degree of fair use of AI-generated information in general in the scientific community? Are there any comments on that, Chris?
That's not something I have a particular insight into. I mean, in terms of fair use, certainly using copyrighted works to train AI for research purposes, as the Copyright Office mentioned in part 3 of its reports, definitely has a higher likelihood of being a fair use. That said, fair use generally doesn't admit of bright line rules for specific areas of practice or things like that. But again, I can say that research use of copyrighted works to train AI would tend to be closer to a fair use.
Thank you very much. Okay, Rehab, please go ahead.
Can we pass to the panel discussion now? Okay, so I'm not sharing here, or Andrew is sharing. We are all the panelists here, and we will be speaking each of of us from a viewpoint or a standpoint. For myself, I will be speaking on behalf. I will be representing the bibliography section and its stakeholders. So I will be speaking on behalf of national bibliographic agencies and national libraries, institutions tasked with maintaining the definitive national records and of collecting the published output. And this opens the door for lots of questions like authorship, copyrightability, the future of libraries collection, and even how we can define creativity, what is creativity, artistry in this increasingly driven AI information landscape.
And yes, so I'm coming more from the perspective of an academic, social scientist working in the field of AI from a kind of management perspective. I think I know something about AI in libraries. After Chris's talk, I realized I know virtually nothing about copyright and AI. It's such a complex area and fast moving, and it seems very indeterminate field anyway. But hopefully I'll be able to contribute something.
Sorry.
Okay. Yeah, maybe I'll proceed. So I'm from the National Library Board of Singapore, and I take care of the resource discovery, which is another label that we use for the cataloging department. My perspective is from a librarian who needs to work with AI, because at the National Library Board, we have a lot of AI projects, both for front end as well as back end. And where back end is concerned, we're talking about use of AI to help with processes, cataloging processes and all that. So my perspective is as the National Library Librarian with advanced AI projects and strategy.
And my name is Cory Lampert, and I'm a professor and head of digital collections at the University of Nevada, Las Vegas, where I run a digitization lab in an academic library like many of my colleagues. I am the one who often is confronted with the question of, can we digitize this, and making that decision every day. And I also work with statewide projects and networked digital libraries, and I think there are many questions that those of us in my sector are asking ourselves about the content we've created and the content we are creating every day. So I'm bringing that perspective to this webinar.
Maybe I should start from my standpoint. So national libraries and national bibliographic agencies, they are custodian, and responsibility is to maintain a verified record of human knowledge. So we have lots of concern around generated AI content and how to tackle this. And sometimes we have some tension between one position and another position. To start with, we'd like to ask you, Chris, to inform us what could be the value, if you can find a value in collecting generative AI material or content, and also where comes the tension if a work is denied copyright protection because it is AI generated, does it still fall within or statutory legal deposit framework and legislation? So the National Library would devise some policy to collect some of those items. And also, if they don't, they could have some concern that they could be missing a large portion of the digital material that are created through AI assistance or AI authorship?
Thank you, Rehab, for that's a lot of questions, and you know, I would say, and they're fascinating, and you know, I've thought about this a little bit about would libraries, you know, because when you say AI created, first of all, that raises the question of, are we talking about like a Thaler v. Perlmutter type of thing where it was completely created by the AI with no human involvement? That might be interesting to have examples of in a library. If you're talking about the vast majority of AI related content that were created with a human being using AI for to make some of the creative decisions. I'm not, you know, I think that's really up to the mission of each individual library. One thing to consider is the speed and the amount of content that AI can create. And if you are, you know, if you find it is consistent with your mission to collect these sort of works, you know, how much of it do you need? Because there's just a flood of it. I mean, you know, you hear the term AI slop, particularly in the music industry. You know, where you have, you know, millions of tracks being uploaded to streaming platforms that are entirely or partially created by artificial intelligence. If you're a music library, you know, do you want to collect those? I don't know. You also, you know, mentioned the idea of library as a collection of human activity, and certainly works that are mixed AI and human expression are partially human activity. Some AI, entirely AI generated, are not human activity at all. But AI itself is a human invented technology. So I'm just sort of raising some questions that you might want to ask yourself. Obviously, I don't have any answers.
Okay, just a question before I hand it over to another panelist. Just a question that popped out like just now from your talk. In that case, if we are going to give a nationality for this work, would it be the nationality of the AI model or the prompt engineer, or these are questions that are really becoming concerns for, or just questions for us as librarians and also as
Right. I mean, I know that for copyright registration, to the, you know, when we ask for the nationality of the author, and it's something that was created with AI, first we have to ask them to disclaim the parts of the expressive parts of the work that were created by AI. So for the rest of the work that was created, that the expressive content was created by the human author, then it would be the location of that human author. But that's just, you know, the United States copyright registration program.
it's crystal clear that it should be co-authors, no just AI authorship. Co-author, human
Okay.
AI co-author. Thank you. That's very clear.
I think I'm up next to say something. So you gave a brilliant overview of the variety of legal positions, and I think you were quite fair on the UK, which is a right mess, really. The UK government has basically said, we no idea where we stand. So it's not a fair question to you, Chris, but I'm interested to know whether you think where the risk lies, because libraries will have to do things. AI has been around for quite a long time already. if they're going to collect anything, they've got to collect it right away. But is there any risk really if the legislation itself is so uncertain?
So if you're talking about the risk to a library of collecting works that are fully or partially created by AI, I have no idea. I would imagine there's storage issues. But in terms of legal risk, unless your collection is, I mean, this is something that was brought up earlier about mandatory deposit or legal deposit. For example, in the United States, legal deposit is triggered, it's only for copyright protected works. So if you are collecting fully AI generated works under under a mandatory or legal deposit regime, that might be an issue to think about. But I'm not sure about the legal risk of just collecting, works that were co-created with generative AI. Maybe somebody else on the panel has some thoughts on that.
Okay, I don't see anyone clamoring to answer that. So maybe we can circle back. We've talked a little bit about collecting. Maybe we can move into my question, which is about creating collections through digitization. As we all are familiar, libraries have been digitizing materials over, the past decades with this mission to increase access. But I'm curious if the panel and Chris, if you have any thoughts, how do we see current AI legal perspectives and the case law, or this, proposed, as Andrew said, it's a bit uncertain, but how do we see where we are legally, internationally, affecting the future of fair use as a concept that's so central to library exceptions for providing access? I'm thinking specifically, could we bring it to a practical level of what would you, Chris, point practitioners to pay the most attention to when it comes to monitoring the practice of fair use in libraries?
Oh, that's a hard question. Because the fair use is obviously largely a common law doctrine. It was created in the common law and then it was statutorily enacted. But as it evolves through cases. And as far as I know, none of the not hundreds, over 100 cases in the United States are against libraries for using generative AI. So, you sort of have to reason by analogy. You did obviously have the cases of the Google books, and there was a companion case to that as well, that the name of which escapes me, where they were using text and data mining to do analysis of a huge corpus of millions of books that had been copied for that purpose. With that, there was a provision, it was understood in those cases that there was no access to the full text of the books that were copied. And, I think that this has come up in the EU a lot, is that there's a difference, or some people perceive a bright line difference between text and data mining on the one hand and generative AI on the other hand. I'm not sure, I don't really have a strong position on that. But I think that there's going to be, it's going to take a while, but there will be some answers about how fair use works in the generative AI space. I'm sure it will get to the Supreme Court level at some point, just because the amount of money at stake is so huge and the future of the copyright industries is in play. So, just keep an eye. There's a website called ChatGPT is Eating the World, and that's all one word. And there's a law professor who runs that, and he does a very good job of keeping up on all of the. That's where I got that map of cases on the slide when I introduced the litigation section. He does a very good job of keeping up with all of the case law and all of the various motions that are filed. So it's not just the results of the end of the case, but all of the motions that are filed and the discovery and all that. So I would recommend that as a resource.
Great, thank you very much about that. I noticed a question in the Q&A. Is there anything in particular with regard to the legal risks of providing AI engines with access to newspapers? Are there any main questions or challenges that we should be specifically concerned with a format, say, like newspapers?
I mean, my understanding of the issue with news is with the news industry's concern with generative AI is more in terms of the competition for new news, so to speak, for the competition for breaking news, for new information. I think that the AI questions about archived information or archived newspapers may be similar to that for other nonfiction works. But the big issue I see, or that I understand, is where generative AI is taking bits of published news information and providing those as answers to questions online, and that thus taking eyeballs away from the source of that information.
Thank you. Should we go on to you, Haliza?
Yeah, if I just have something to comment after Chris answered just now about the newspapers. I was just chatting with my IT colleague about the reproduction or the prompting and the use of the results of the data mining that AI uses. Apparently, we can install guardrails that can be configured to recognize the request. And so, if to prevent the outcome from being a total, copy paste or in the style of or even all the points of that particular article from being reproduced. And I think guardrails play a large role here in terms of fair use, especially for newspapers, but not just for newspapers, other content as well. Which brings me to my question, which is that, in using the generative AI tools to discover content, this is to enable users to access and query the content for in-depth responses. And we were thinking that the training data alone will not be able to control how users intend to use the data. I talked about the guardrails. I'm not an IT person, so I can't quite go into that, but there are guardrails that we can install. In Singapore, we have a very active technical department, which is called GovTech, and they actually have something called an AI Sentinel, which is made available for use for any of the government agencies when they are coming up with their AI products. In fact, I ought to stress that in Singapore, we have a totally different view of AI in the sense that, we're a tiny country and we rely a lot on human capital. So we're looking at ways how to harness AI as a strategic advantage, which is why we have a roadmap, we have a strategy, a national AI strategy, and for National Library Board itself, we also translate it down into guidelines and strategies, down all the way to our cataloging side. So back to my question. If we have, with all these issues, as a complementary measure, would it be practical for a national library embarking on this to onboard large copyright owners, like the publishers, the authors, government bodies with proprietary ownership of content, etc., upstream before the work is even done, onboard them? And if so, what would be the agreements that we need to consider? I suppose that goes to Chris. Do you have any inputs on that?
That's interesting. I was just talking to a colleague who I believe is watching this. Hi, Abby. Who about Norway, and apparently Norway has reached, their national library has reached agreements with all of the major Norwegian publishers and content owners in order to grant permission for the library to use all of their content in creating a Norwegian language large language model. So, there's definitely precedent for that sort of thing, especially in smaller countries. Obviously, it's a lot more doable, I would think, but that's I don't have any really suggestions over what the best way to do it would be, but I would, if you, you might want to look up how they did it in Norway.
Thank you. I suppose it's all about the agreement between the owners of these content publishers and us. And to that end, I think we need to maintain a very healthy dialogue with them and not, present the optic that AI is out to take over their work, etc. So I think a lot of conversations need to go into the picture in any of such endeavors. Yeah. Rehab, sorry, you were saying something?
No, I thought that it was my turn to. Okay, very much aware of the time. We have about 20 minutes. So I would like to raise some points. We are going to consolidate. I don't think that all the discussion points will be tackled, and maybe we are crisscrossing here. So we are going to consolidate and be selective about the question that we asked. But we have to make an important announcement now, is that we have a survey that we would like to share with you, for you to share as participants your perspectives and the status in your respective countries. Maybe Andrew, you could say a couple of words about this survey and our aim.
Yeah, well, it's just a very informal opportunity for you as an audience to input your views on things like, what's your stance on what would make something make it needed to be collected, even if it had an AI dimension to it, or how do we resolve this tension between open access, promoting open access, and the exploitation of that basically by these big tech companies. So we've got a few questions, and I think we're going to post Haliza has posted her poll.
Yeah, I've put it up.
Yeah.
So you can download that, and it's a Google form. Yeah.
Can you share it again, please, Haliza, because some people didn't notice that you shared some link. You can take this poll. It's a very, it's optional, and it's a very short survey, just to like your perspective on things, and if and something to share with us about your the national landscape. Okay, so trying to be selective about what I can ask. There is a case here. We have a tension that is created by, okay, I'm referring to concrete cases like an international agency has recently convened a working group to look at developing a policy to address AI-generated and AI-assisted creators. So a question, and also IFLA section has received the question around if we have existing policy or guidance or guidelines for the metadata for AI books, especially marking if a book is partly or even wholly produced by AI. And here is the tension we are facing between how we detect and ban generative AI content from entering our library catalog and the express need for national or institutional bibliographic and cataloging policies to evolve in order to be prepared for processing non-human authorship and AI assisted content. I'm not, I know that it's a complex question. It involves in big part the professional library professionals themselves who are raising those questions about should we start looking into some metadata for cataloging those items. So it's not maybe for Chris exclusively. We won't throw the ball to him to answer this, but it is for the panel. It is for Chris and for us as panelists. What can be foundational principles that can help us build informed metadata policy here? Chris, do you have any idea or would you like to start?
I would think this is an excellent question for the librarians on the panel.
For me, I think Rehab knows my opinion. We've talked about this. AI is being seen in the cataloging rules as an agent, as a work rather than an agent. And I think there's a lot of pros and cons thoughts about this, a lot of confusion too among the catalogers, at least in my team, because there's with the AI producing the work, they become an agent, but actually the AI itself is work. Yeah, so that's one of the tensions that Rehab was referring to.
Yeah, I'll just add that we've had conversations in our AI policy group about making use of some sort of field. I don't know if it would be a creator field to indicate, in the interest of transparency, if a work has been co-authored with AI or if AI was used in the creation of it in the metadata, so that could be a filter that researchers could use to understand where the content was coming from.
From the standpoint of the IFLA section, especially for bibliography, cataloging, and subject analysis and access, and maybe the Committee on Standard, we see that since we are receiving this kind of question, we should start thinking about if we could not develop some guidance or policies, but to explore the matter, to start by exploring this matter and its impact on metadata, and we see how things will go. For now, we don't have something in place, but this is how I think policy guidelines and standards usually emerge.
Another good point that's been brought up in the chat I want to point folks to is the mention of the United States ADA digital remediation efforts that are going on for accessibility, and this effort to make content and material online machine readable for end users could also be used by data mining and Gen I training. So it's an interesting confluence of two main initiatives. And I think that's a really interesting comment that was made in the chat. If anyone has comments on accessibility work along with the AI context. Maybe I can draw attention to another question that came in through the Q&A. I think this is an interesting topic for the panel, particularly because we have an expert in AI and ethics here on the panel. The comment/question is, for collecting works generated by AI, we might encounter risks of collecting hate speech, given the material has not been read by a publisher. These laws would be national level. So do the panelists have any reflections on, the inclusion of things like hate speech in these types of collections?
I think it would depend on the policy of the institution. Yeah. And the culture of the country, for that matter. Yeah. For like in Singapore, where we have different ethnic groups, discrimination, etc., is illegal. It's totally controlled. So as a library, we will have to also bear in mind such a situation. And so it's different, I suppose, from country to country.
I thought your question also was directed to Andrew here, because Andrew is and the AI SIG are concentrating and focusing much on ethics and this.
It does relate to something that I was wondering about that is interesting to discuss. I mean, libraries do contain a lot of material that historically would have been acceptable, but now is not acceptable. I'm not sure it's hate speech, but it's certainly very discriminatory and biased and reflects coloniality. So we have to deal with that problem. AI is just another manifestation of that. I'm just wondering which are the really novel problems of AI, because we've faced lots of challenges before to copyright, like the Google Books case. Is this a dramatically different case from all those? Is it something that we can't solve, that it will actually fundamentally disrupt the copyright regime? Or is it just another sort of little perturbation in a long history of historical problems? I don't know if there's an answer to that. I'd be interested to hear what other people thought about, what is it about AI that makes it so different, if anything?
It falls, I think, under the umbrella of responsible use of AI and other matters also. And I think that some of the library practices are being changed in order to address this type of historical discrimination, legal speech, and for minorities, for even for gender discrimination, on non-tolerance, many things. So I think it's it's a question also for librarians and practitioners. Since we are managing those vocabularies, we are managing those, it's our responsibility within the development of standards of vocabularies and also on practice. But I think that the matter is also larger and broader than just libraries.
I think, of course, the scale is quite intense. And I believe that one of the perspectives I've seen is that librarians used to be able to kind of give patrons or communities a sense of how to, assess the quality of information. And there's a certain blurriness that comes with generative AI and other AI outputs where it's very hard to apply those assessments. And these tools are becoming quite, ubiquitous. Students, people, communities are depending on them for answers. And I think we've yet to figure out how to work them into our information literacy landscape.
I think those hate somehow are or those discrimination also are somehow inherent in the training materials themselves. There are historical things. So when you put those materials, they have, because as Andrew has pointed out, that it's recently that libraries practices and policies have started to change in this area in order to address those discriminating or hate speech or whatever. So I think that also the training material, they have lots of this vocabulary. So if you trash in, is trash out. And yeah, it's the same thing. So I think that responsible use of AI should be applied on ourselves before we can just make like a general statement about what AI can give us, because it doesn't work from like its brain. It has material ingested, and it just give you what they have. Yeah.
This might be a good point to turn to a comment in the Q&A from the National Library of China. This is a question about how AI systems frequently generate false information or suffer from hallucinations. And the question is asking, how can we strike a balance among copyright protection, fair use of AI, and the issue of data quality? And this could be for anyone on the panel. And we just have a few minutes left, so think quickly.
I suppose I just want to quickly mention, I suppose, the need for more public. One of the fundamental problems, surely, is that we've got AI that's primarily created by big tech companies to make money. We need more public AI. We need more community AI, really. And that's where libraries do play a really powerful role, like Chris mentioned about in the case of Norway, working to create better AI that is a lot more reliable. The problem, my dimension is, going back to the previous question, it seems to me is like the whole landscape of how information is produced is changing in very fundamental ways that are quite hard for even us to grasp, where we're information experts. How do you convey that to users and also make them realize this is evolving? there, I think is really what Cory said before. It's like, well, what constitutes literacy about these finding information is just changing so rapidly that we got to teach people to be ready to relearn their skills in a short while.
For me, I will add on to that. I suppose it's quite, I had thought it's quite common practice that currently when we are introducing AI tools, AI services, and there's an issue with hallucination, etc., that as a library, we have lots of structured data. We're a trusted source of information. And using technologies like retrieval augmented generation, RAG, and using our metadata. And in fact, the current project I'm working on is where we're trying to use our knowledge graph to feed, to be combined with vector search so that, natural language questions can be queried and the results are based on curated information. Catalogs are created, catalogers, and even when we do our entity relationships, reconciliation, disambiguation, all this is being curated by humans. And this becomes that trusted source that I'm talking about. With these kinds of structured data that is controlled, that is authorized, it will help with, that's what we discovered. It does help to reduce hallucinations. The only issue is if we use basic metadata versus something that is based on the entity relationship modeling, we find that the semantics of the words in the vector database can be a little skewed. So, for example, a query for a book which does not have any a direct reference to supernatural fiction, which is what the book is about, may not bring about a related book. It may bring about something else which is related to the title of the book, because it's still, the vectors is still using proximity search and so on. So when we try putting in a bit more of this more thorough, curated, which we are trying now, and I'll let you know whether it will work by next year. What we are expecting is that such hallucinations will reduce a lot. So yeah, we are still early days, and I think we still need to try, especially as libraries, we're not big tech companies. We may not have the expertise or the money for that matter, but we do have the support. Like in my country, the government is totally coming up with an exception, which is called the computational data analysis, that actually allows us to digitize, to use book or resources content without having to ask for copyright permission. It's an exception, but of course there are a lot of stringent controls, like we're not supposed to use it for dissemination, so it's only to be used for data mining, and it has to be lawful access in the first place. It has to be purchased or deposited using legal deposit. So things like that. Yeah. So it's a pros and cons, and we're still testing on waters. Rehab, over to you. Are we going to go through the rest of the questions? I think we're at 10:30.
I know we are a couple of minutes beyond time. I would like to send an envoi or raise a question that doesn't need to be answered, but if you, Chris, have any thoughts about it, it would be great. Very recently, the Academy of Motion Pictures, Arts and Science, the Oscars awarding institution, has officially clarified that AI will not be eligible to win Oscars without significant human involvement, completely prohibiting AI-generated actors and scripts from a word consideration. That was following an incident that they created the AI model through AI model. They created a synthetic actress, and they announced that she is currently in communication negotiation with the agent and agency in order to star in movies. And that was the reaction of the Oscar awarding institution, protecting the movie industry, the cinema industry, protecting also actors and actresses. Do you have some reflection and thoughts about this? And who is in other domain the institutions that can protect authors, that can protect creators, or that can protect the public also from erroneous content? Chris.
Okay, thank you for the question. That actually, in terms of the last point you made, I know that the Authors Guild in the United States has a program where authors can sign up and get a certificate that their books are 100% human authored, and then they can put that their publishers can put that certificate in the book. So that's one thing that I've been actually thinking about a little bit, which is when you think of food and food that's labeled as organic or non-GMO, and I wonder if cultural products will start to be labeled as human authored or non-AI authored, and if that will be like a premium indicator. I think that it's early days in that sort of thing, and I also wonder, at some point AI is going to be so wrapped up in the fundamental ways that we create, or at least this is a possibility, that it's going to be really difficult to, right now with the copyright offices registration program, we ask people to disclaim the AI parts of their the parts that AI created of the work that they're submitting. We don't ask them to identify those parts, just that to the extent that they do exist, that they disclaim them. I'm wondering if it'll get to some point where just the tools that we use to create things will be so based on AI that it'll be difficult to do that. And I'm thinking of, when synthesizers became more ubiquitously used in music. Some acts would say no synthesizers on their records, which seems kind of silly now. Or say, we used a human drummer, not a drum machine. And so I think that right now you can draw a line between AI created expression and using a tool like a drum machine or a synthesizer. I think that those lines can be drawn. I don't know if they'll be able to be drawn in the future, though.
Thank you so much, Chris. That was so informing. How they reacted to what Oscars, the awarding academy has said. They said, okay, it is here, and we only ask you to allow this as a new genre on a platform like Netflix. So they are kind of imposing this. And we fear that over time it will be here and we'll be dealing with fully synthetic genre of movies that has audience and public, and I think that as librarians we are not for now equipped to make any position about this. Any other thoughts on this from the panel? Okay, because shall we wrap up the webinar?
Rehab, could you just explain to the attendees, we've had some questions about the slides and recording being made available. Did we record this? No, we didn't record it. Sorry. How will the slides be accessible after?
Okay, depending on whether Chris will be giving out the permission to publish them in PDF format, we will make them available. Otherwise, they can watch the recording also. They will find because the presentation by Chris had like talks, not just the slides. So the slides were like just an outline, but we strongly advise that they rewatch the recording for the full presentation by Chris. We'll come back to you on this with when we announce publishing the recording. Are you closing the webinar, Andrew? You close? I don't close.
Well, okay. I think, yeah, we're a bit over time. Thanks to everyone for attending. Thanks so much for your questions. Thanks very much to Chris for sharing his expertise, and for the rest of the panel. Wonderful questions and answers. We all learned a lot. We still don't know a lot, but that's AI for you. So thank you so much to everybody.
Thank you very much.
Bye.